Good morning to you and welcome to the session Arbitration, Does the Seat Matter? Arbitration is the #1 dispute resolution mechanism for international disputes. Virtually all cross-border agreements have arbitration clauses, and there are many good reasons for that. Arbitration ensures worldwide enforceability, speed, confidentiality, just to name a few. Arbitration also has become a big business. The profits are not so much collected by arbitrators, even though they become increasingly busy and tour the world, and not so much by institutions. Many of those operate on a profit-driven or non-profit-driven aspects, but law firms, certainly, which have big teams working on arbitration, and more specifically also governments. A study by the ICC made some years ago has come to the result that the total cost of arbitration, out of these 2% go to the institutions, approximately 15% go to the arbitrators, and the remaining 82% are the parties' cost. And in 2012, Charles River Associates, a expert consultant seated in Toronto, Canada, has come to the result that for the city of Toronto in Canada, the total impact of arbitration on its economy for the year 2012 was 200 million euro. And that was based on approximately 425 arbitrations, with one arbitration having 475,000 euros each in cost, expenditure, total expenditure to the parties. And in fact, many cities with that driving are very interested and anxious to promote themselves as venues for arbitration. When you look at the different arbitration venues and the different institutional rules in more detail, and in particular also at the, as I say, a little bit exaggerating, advertisements being made, for a non-expert, it is very difficult to decide and to evaluate which criteria to apply. Which arbitration clause should I put in my contract? London, Paris, or Vienna? If I opt for Vienna, should I use the Vienna rules? Should I use ICC, or should I use the UNCITRAL rules?